Right, good morning, everyone. My name is Sophie Capo-Bianco. I'm a senior associate at Expatriate Law, and I'm joined here by my colleague Ferenc, who is a family lawyer in Belgium. Thank you very much for making yourself available this morning. It's greatly appreciated. I know how very busy you are. So I just wondered if you could introduce yourself and let us know the firm you work at and the nature of your work.
Sure, Sophie, many thanks for inviting me to this call. I'm Ferenc Ballegeer. I'm a tax lawyer, a family lawyer and property lawyer in Brussels, in Belgium. And FB Tax, which is my own firm, specializes in advice in the complex matters of taxation, property law and family law. So if you are a private individual, if you are an entrepreneur, if you have a company, business or private, I think we might be able to help you regardless of your origin and your personal situation.
Excellent. Sounds very, very interesting. Right, so I have a few questions for you today, just about the local laws in Belgium. So I'll start off with question number one, which is, can British expatriates living in Belgium divorce in your country? And if they can, how long would they have need to have lived in Belgium for?
Well, the answer is yes. British expatriates living in Belgium can divorce in Belgium. The competent court being the family tribunal here. Right. Under Belgian conflict of law rules, the divorce proceedings will be governed by Belgian law. Luckily, there is no minimum period of living in Belgium for this. The spouses must have their habitual abode, as we would call it or translate it in English, in Belgium, which would be so or will be so if they live in Belgium. The laws of the joint nationality of the spouses would be exceptionally applicable if the spouses do not live in Belgium nor in the country of their last joint abode.
Right. Okay. Very interesting. And one of the main aspects, I suppose, that our clients come to when they're choosing which jurisdiction to sort of divorce in, whether it's the country they're living in as an expatriate or England, is how the different countries divide the assets. So my second question would be, how do the courts in Belgium approach a division of assets on divorce?
Well, that's a very good question. As you know, Sophie, Belgium is a civil law jurisdiction. So that basically means that our legal system is based on codes and written laws, which is, I believe, quite different from what you are accustomed to. The family tribunal or the family chamber of the Court of Appeal at a later stage would have to investigate which law applies to the matrimonial property regime of the spouses. This may be Belgian law, but quite often also foreign law, because there is a foreign prenup, for example. Mm. If needed, prior advice on such foreign law will be requested by the courts, and for sure, the lawyers of the respective parties will need to assist the judge in that.
Right, okay. So does that mean then you would get an expert from, or a lawyer from a different jurisdiction who would then provide an expert report, which would then be presented?
Well, indeed. So the court would require, I would say, an opinion on the foreign law and on its consequences, on how to apply it. And on the basis of such written statement or opinion, a decision would be taken.
Okay. Okay, interesting. And another usually bone of contention, I would say, between sort of the clients I have, comes down to spousal maintenance. So the payer doesn't want to pay much or anything, and the person who's receiving the spousal maintenance usually wants more than they're usually offered. So So my third question is spousal maintenance awarded in Belgium? And if so, for how long? Is there a specific timeline? Is that related to the length of the marriage or?
Indeed, spousal maintenance is possible. If the maintenance claim is governed by Belgian law, which is of course the prior question, pursuant to EU regulation for 2009, that is, spousal maintenance may be awarded. Mostly, the ex-spouses agree on the matter in their settlement agreement. So before they would go to court. Okay, if such agreement is not possible, it may happen, of course, a claim may be brought before the family tribunal, and the amount of the maintenance will be based on the needs of the claimant, taking into account also the standard of living and how the spouses organized their family life during marriage. The maximum duration is the duration of the marriage. The maximum amount may also be limited, of course, by the income of the debtor of the maintenance allowance, obviously. The claim will not be allowed, very exceptionally, if the claimant committed domestic violence or other eligible related, family-related crimes, which is, of course, a quite obvious exception.
Wow, okay, that's very, very interesting. So in England, we are very much based on needs when it comes to spousal maintenance. As such, there's not a cap on, it's for the maximum relation to the length of the marriage. But there's no such rule in terms of, if there's been domestic violence and there's no spousal maintenance. So how is that sort of presented to the court? Does there have to be a police report, or do you have like a non-molestation order, a restraining order? Does that have to be presented to prove the domestic violence, or?
It would for sure need to be much more than just a police statement. I think a conviction is necessary. In that sense that, of course, as long as a person is not convicted of a certain crime, he is deemed to be innocent, of course. Mm-hmm. So a police statement would definitely not be enough.
Okay. Very interesting. Very interesting. Okay, so my next question is, are there any rules in Belgium in terms of excluding any assets in divorce? For example, any assets that were acquired before the parties were married, or any inherited assets, or are they all included in the matrimonial pot?
No, indeed, we have such rules, which I hope will comfort most clients. The answer to the question actually depends on the applicable law to the matrimonial property. If Belgian law applies, well, then by default, no prenup or marriage contract, if there is no prenup or what we would call a marriage contract, the matrimonial property regime by default excludes both pre-acquired and inherited assets. Mm-hmm. Such exclusion also applies to spouses under a separation of goods marriage contract. The burden of proof, however, and this is in practice sometimes the difficult one, the burden of proof, of course, is on the claimant. However, and married couples are subject to statutory presumptions regarding the ownership of assets. For example, if you can't prove ownership of a specific asset, well, the asset will be regarded as being divided 50-50 between the spouses, or would be regarded as a common asset. Mm-hmm. For immovable property, such problems, burden of proof problems, are rare. But the situation may be quite different for movable assets if there are no written records or specific contracts or agreements. It must be noted that under the by default matrimonial property regime under Belgian law, all income of the spouses is professional, is a joint asset. For example, professional income would be a joint asset. Also, income of the pre-acquired or inherited assets are joint assets. So the pre-acquired and inherited assets are not joint assets as such, but their income during the marriage is a joint asset. For example, rental income of an inherited house would be a joint asset, although the house itself, which is inherited, is not a joint asset.
Oh, how interesting. Okay. Yeah. And would that include things like pension? So the income of the pension, would that be included as a joint asset, but the actual overall value of the pension?
Well, it depends on the origin of the asset, but if the pension would be an employer's pension, for example, well, this would be regarded as part of the salary, and then it's an income. You see, so it may be a joint asset indeed.
Okay, very interesting. Thank you. Right, and then finally, my last question comes with regard to the children. One should probably say that should have been my first question, as they are, of course, the paramount consideration. But what is the starting point in Belgium in respect of children arrangements after a divorce?
Well, the starting point would be the agreement of the spouses, which most of the time is based on an equally divided custody. Of course, this is not always possible, but this would be the starting point. Spouses divorcing with mutual consent, because there is not always, a quite tenuous relationship, must agree on the matter before the divorce can be accepted by the family tribunal. So basically you would draft a settlement agreement, and a specific section of the settlement agreement would be on child custody. The family tribunal must request the advice of what we call het Openbaar Ministerie, le ministère public, and such advice will look at the child's interests and the child's welfare, logically. And the family tribunal, based on that advice or on its own initiative, may also request changes to the settlement agreement, notably regarding child custody arrangements that are in that agreement. Of course, taking into account the child's interests and the child's welfare.
Okay, so what happens then if the parties can't agree at all about the children arrangement? So are they sort of stuck in a bit of no man's land as it's such, because then they can't issue their divorce? So they have to have this agreement about the children before they can proceed? Well,
the prior agreement is only necessary if the spouses choose for a divorce by mutual consent. If the mutual consent is not possible for whatever reason that may be, well, you can take the path of the divorce on the grounds of the fundamental disagreement between the spouses, which is another procedure, but which allows the court to finally strike the court itself if it is really necessary, because nobody can be forced, of course, to be stuck in marriage, because that would be worse for both the spouses and for the children. So if a mutual consent procedure is not possible because there is no mutual consent, then you have the second path, and the second path is the path of spouses that want to divorce but do not consent on any matter, and then, of course, all claims will be brought to the court, and the courts will decide based on the claims of the parties and of the written laws in the Belgian codes, if Belgian law applies.
Okay, very, very interesting. And just on that then, I've just got maybe just an additional question in terms of, say British expatriates are in Belgium and the mother wants to relocate back to England with the children or the child, and the father doesn't agree, so she has to make an application in the Belgian court. Sort of, and this is probably, probably a very speculative answer, but how often or how successful would such an application be? I mean, we know it as a leave to remove application, so you're asking the court for permission to remove from that jurisdiction and relocate. Is that quite common in Belgium to have those sort of applications?
Well, unfortunately, it's becoming more and more common, given the fact that, of course, international families, well, there are more international families. And if there would be no consent possible between the ex-partners or the ex-spouses, well, the tribunal would have to decide. And of course, the child's interests and the child's welfare will be very important to that question. If the child would have a certain age and would go to a Belgian school in French or in Dutch or whatever, it may be more complicated to have a successful claim on such matters. If, for example, these are merely hypotheses, because this is really on a case-by-case, well, on a case-by-case, well, it will be a case-by-case decision, obviously, if the child is very young, and it would be clearly in the interests of the child that the child would move to England and Wales, for example, England or Wales, well, then it may be awarded. But Belgian family judges are prudent and reluctant and take very much into consideration the child's interest, also, of course, the parents' interest. But if these are really conflicting, it may be that the child's best interest is predominant.
Okay.
But of course, it would be a case-by-case decision. Absolutely. And you cannot answer the question.
Yeah, of course. Thank you very much. Well, I think that's everything from me. That's been so very helpful, and I'm so very grateful for your time. As I said, I know how very busy you are, and you have lots of presentations and lots of hearings coming up. So from everyone at Expatriate Law, we're very grateful for your help. And of course, if we get any inquiries about Belgian law, then of course we will forward them over to you as our resident expert. But from me, that's it. Thank you very much, and I hope you have a great rest of the day.
Thank you very much, Sophie. Have also a great rest of the day, and well, I hope to see and speak to you very soon.
Absolutely. Bye-bye. All right, take care. Bye-bye.
Take care. Bye.